Now that we have a little bit of a sense of what medical futility is all about, and maybe an idea of why this is sort of an interesting problem for us and just for medicine in general, we want to start now to look at various arguments regarding things like who should make determinations about futility, what sorts of obligations physicians have, and that sort of thing, some of the considerations we concluded the last clip with. So what we're going to do here is look at some of the discussion in the piece by Stuart Younger, and then look at Stephen Miles' assessment of the Helga Wangley case. And the Younger piece is really going to focus on the question of who should decide when treatment is futile and when it should be terminated because it's futile. And most of what Younger is doing is just responding to a proposal from another physician named Donald Murphy. Murphy proposes that physicians should be allowed to unilaterally decide when a patient should not be resuscitated. And that word unilaterally is really important there, because what Murphy is actually suggesting is that physicians should be allowed to do this without consulting with the family, without sort of input from loved ones and things like that. And you might think that that's a very surprising view. It's a little bit of a dated view. It's certainly not a view that would be endorsed today, because we currently have a climate where patient autonomy is held in extremely high regard. It's thought to be like sort of the most important value in medicine. And Murphy is suggesting something that is akin to the kind of old doctor knows best paradigm that this autonomy paradigm replaced. But at the same time, Murphy has a couple of not implausible reasons for this proposal. He says, first of all, if we adopt this proposal, it's going to keep families from having to make these kinds of difficult choices themselves. It's always hard to, Murphy says, and he's probably right about this, it's hard for families to make these kinds of choices. It involves sort of really sensitive issues and really difficult emotions and things like that. And it's just a very, very challenging and trying thing to ask a family to do, to decide about whether or not to stop treating their loved one. And so we can sort of take that burden away from the families by letting physicians just make these decisions on their own. Murphy also says, look, this proposal would have some other benefits too. It would prevent the use of resources that's noticeably disproportionate to the expected benefits of the care. That's one thing that's sort of troubling about medical futility cases, is that what you get for what you put in is almost nothing. And oftentimes we're talking about extremely expensive kinds of treatments, as you'll see in the Facing Death film. And we're talking about transplants and things like that, sort of expensive technology and that sort of thing. And what you get back for in return for the use of those resources is not much. I mean, it's sort of hard to justify for those reasons, and that's one of the reasons people find this kind of care sort of troubling and problematic in a lot of ways, is because it is such a disproportionate benefit in comparison to what it costs and what we use. And Murphy also thinks that we should adopt this proposal because physicians are actually uniquely qualified to make these kinds of determinations about when care is futile. They're sort of in a better position to do it than others. Now, Stuart Younger doesn't agree with this. He wants to challenge Murphy's proposal. He thinks that really it should be the families that make these choices. And he says, first of all, it's not obvious that what Murphy is suggesting would lead to radically different outcomes. There's good empirical data suggesting that when people are counseled in the proper way, with sort of the right kind of education and support and that kind of thing, families will usually opt to terminate care in these futility cases anyway. So the thought is, look, we shouldn't just sort of take the decision-making authority away from families and like unburden them. We should just be more involved in counseling them and helping them to figure out what they want to do and what they should do. And oftentimes when we do that, families make the exact same choices that the physicians would have made. So we don't get sort of radically different outcomes there. So the thought is that, look, there's another way to sort of get the same kind of good result with regard to unburdening families. Younger's also concerned about this appeal to resource allocation and sort of responsible use of resources, because although that's important, it's an important part of this debate, Younger sees that as an issue that occurs at the level of policy and not something that should be part of a physician's decision-making process. So the idea is, like, when physicians make choices about treatment, they shouldn't be worrying about sort of responsible use of resources. They should be worried about what will help their patient get well. And so Younger finds that appeal a little bit problematic and a little bit troubling. And finally, Younger wants to challenge Murphy's claim that physicians are somehow uniquely qualified to make these kinds of assessments. Younger says, look, these futility, as we saw in the previous clip, decisions about futility often involve value judgments, and that's not something that physicians are trained to do or that they ought to be doing. It's really not. It's outside the scope of medicine altogether, and so it's just not something that we ought to be asking physicians to be involved with. So ultimately, and this is sort of two different ways of thinking about one of the questions we want to answer here, which is who should decide? Who should make decisions about when care is futile and sort of not worth pursuing further? And Murphy has given us a couple of reasons to think that it should be physicians, and Younger has tried to respond to those, and in doing so suggested some ways that this debate is going to proceed with this big question about how prevalent value judgments should be in medicine and what kinds of decisions should really be in the hands of physicians. To get a little clearer about this, though, let's take a look at a case. And this comes up in the piece by Stephen Miles. This is the case of Helga Wangley. It's a really famous case of an 85-year-old woman who was living in a nursing home. She had a stroke or something like that and required emergency intubation. That occurred in January of 1990. By May, she'd had additional complications and was unconscious more or less all the time. By late May, she was declared to be in a persistent vegetative state, and they started talking about discontinuing respirator support for her. At that time, her family demanded that respirator support continued, although initially it wasn't clear whether Helga's preferences were known. As the case progressed, her husband eventually took the position that Helga had told him that she did want this sort of treatment. So we went from not really sure if Helga really wanted it to a kind of insistence that she did. But the family was pretty adamant throughout that they wanted support for Helga. By October of 1990, respirator support had been declared to be non-beneficial. It was not declared futile because it was a life-prolonging treatment. This is something that's going to come up over and over, and you're going to see it and have to deal with it again on the discussion board. These cases of treatment that is life-prolonging and not a burden to the patient because she's in a persistent vegetative state. She's not experiencing any of it. But that is in some sense not worthwhile. It's not particularly valuable. It's sort of unclear like what the point of it is. There were repeated attempts, and this sort of went back and forth in court, to discontinue support, but what the court kept confirming and didn't really waver on was that in this kind of case where we don't know what the patient would have wanted for sure, her husband is the surrogate decision maker, and he just continued to insist that she would have wanted this. And because the hospital just really wasn't sure what its obligations actually were in a case like this, they did not sort of push harder to withdraw support. Helga was unable to be transferred. They tried repeatedly to transfer her to other places, and that never was successful. Ultimately, she died of her underlying injuries, and the bill for her care came out to $700,000. That's for one patient, almost $750,000, just to keep her on a respirator for 7 months and then have her die of her injuries. That was paid, and this is what people find really problematic about this case, it was paid by Medicare and private insurance, which means that if your parents paid taxes in 1990, or you paid taxes in 1990, probably some of you were born in 1990. That's, wow. Anyway, sorry, revealing my age a little bit. That means that your parents or whoever, the taxpayer, paid for Helga Wangley's care. And the private insurance issue is problematic as well, in part because people who are part of that insurance group may or may not have sort of been consenting parties to paying for that kind of care. Now, Stephen Miles is a physician who was asked when this case was going on to make a determination about whether respirator support was obligatory. And to write it up, and it was published in the New England Journal of Medicine, which is one of the two most influential medical journals out there. So kind of a big deal for this to come up in that particular publication. And what Stephen Miles determined, although he was unsuccessful in convincing anyone that they actually could terminate support, especially convincing any judge or sort of legal body that this was the case, he did determine that support should be withdrawn. And he gave basically 3 reasons for this. He said, first of all, we shouldn't think that respirator support is obligatory here simply because the family requested it. A request for treatment does not obligate physicians to provide it. For example, patients are not entitled to treatments that would injure them, treatments that are just medically inappropriate, or treatments that have no medical efficacy. One example that comes up a lot is, and that I mentioned earlier in the previous clip, is things like antibiotics for a flu or a cold or something like that. That's not medically efficacious, so technically physicians would be sort of within their rights to deny that kind of request, and there's a lot of data that's suggesting that they really ought to do it, even though there's also data indicating that they don't and that they feel pressured to honor those requests, even though they know that what's being requested is not going to be medically effective. So that's one reason Miles thinks we shouldn't regard Helga as being entitled to respirator support just because she wants it or because her family wants it. And Miles says, look, in general, the claim that a patient is entitled to whatever treatment they want or their family wants, that is really problematic general implications. It would effectively put all the authority over what kinds of care is provided into the hands of patients, and patients often make, fairly asinine, outlandish requests. And one thing that we really want physicians to be able to do is resist those requests and sort of guide medical care in a sort of well-informed way. And if we were to interpret patient autonomy in this very strong way, we'd sort of lose that. We would lose that, and it would just lead to all sorts of problematic outcomes if it were taken as generally true. And third, Miles says, look, it's just unfair to provide medically futile treatment to a patient when their care is being paid for by either private insurance or public programs. That's not something that anyone paying into those programs has agreed to, and it's putting a very significant burden on those individuals who turn out to be the ones paying for that care. And whether you disagree with Miles or not, whether you think he's onto something or you have some sort of quarrels here, the point is that we can separate two kinds of questions that we want to think about. One is whether physicians are obligated to provide fetal care to patients who want it, and if so, under what conditions. And the other is who should pay for this care when it's desired and the physician is willing to do it. Those are two sort of separate but important questions about medically futile care, because it's one thing to say that physicians are obligated or not to provide it, and then another to sort of have this discussion about who should actually pay, especially since the bill is often very large. So on the one hand, we've got a concern about obligations of physicians, and then the other has to do with obligations of society in general. Okay, so that's going to conclude our discussion of the Younger and Miles piece. Go ahead and complete the question below, and we will then move on to looking at this issue of physician obligation a little bit more closely.